And we are live. Hello, everybody. Welcome back to your Immigration Compliance Corner. Today, we're going to talk about how DHS proposed a new rule on work authorization, which could have I-9 and E-Verify compliance implications. So we're going to do a high-level review, just a very basic summary, because there's a lot to cover about what this proposed rule actually does, and more importantly, what it means for you as an employer. My name is Emily Brown, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. We are a private immigration law firm specializing in immigration compliance and federal litigation, and we come live to you every Wednesday to talk about immigration compliance topics related to I-9, E-Verify, or certain visa program related compliance. As always, before we get started, everything that I'm going to share today is general educational information only. It is not legal advice. Immigration law changes frequently, so for guidance tailored to your business, be sure to consult a qualified immigration attorney. So the first thing is that this new rule from DHS related to work authorization is a proposed rule right now. And if you've been following along in the past few weeks, we've been talking about notice and comment rulemaking and proposed rules. And so right now it's a proposed rule, and it is open for public comments until August 4th. So after we go through all of this, if you feel your company is going to be impacted, now is the opportunity to submit a comment to DHS for them to consider before they issue a final rule on these topics. The second thing, you'll see a lot of people describing these rules as affecting non-immigrants, but that's not entirely accurate. The people at the center of it, of the biggest changes, are parolees, deferred action recipients, and people with final removal orders who have been released from detention on supervision. So if your HR team reads the headlines and think, oh, well, this doesn't touch any of my H-1Bs, like, yes, you're right, but they could be missing some of the things that it could touch that could still touch your workflow as an HR representative when it comes to I-9 and E-Verify compliance. There's two main sets of changes. There's a broad set of changes that really cover almost all of the areas of discretionary work, which means almost all of the categories that could be on an EAD document, an employment authorization document. So this could include adjustment of status. If someone's applying for a green card, they can get an EAD while it's pending, H-4 spouses, DACA recipients, and more. And for all of them, three things are changing, which I will get into. Then there's a second set of changes that are really narrow, and they only hit three groups. So that would be parolees, deferred action recipients, and people who were with final removal orders who have been released from detention with orders of supervision. So that's where the heaviest change lives, and I will get into those changes as well. And one thing I do want to quickly touch on, just to cover the basis, is that this rule is not touching asylum applicants when it comes to their work authorization. Asylum is being handled in a completely separate rulemaking, so we're not going to be talking about asylum seekers today. The first set of changes. So these are the ones that reach almost all of the different categories of EAD cards. The first one is there's going to be a criminal screen now that's required. So if someone's been arrested, charged, indicted, or convicted of any criminal act, or admits to a violent crime, or there's gang or terrorism evidence that could be counted against them for their work authorization application, unless there's a strong public interest reason to approve it anyway. So there's two things to notice, is that this could reach sympathetic people too, because it doesn't have any carve outs for victims of crime who are seeking a U visa or a T visa, for victims of human trafficking, or DACA recipients. The second broad requirement from this proposed rule is for biometrics. So everyone is now going to be required to do fingerprints and a photo, and then the DHS will run it against an FBI criminal history check before the employment authorization card is issued. Third, this is the broad change that's kind of a sleeper and could be affecting more employers than people might initially realize. So right now, when a status under the EAD expires, the card can keep running until its printed expiration date. So under this new rule, the card is actually going to automatically expire if the underlying basis is no longer there. It ends. So sometimes they could get an EAD card with a longer expiration date into the future because maybe it was more of an ambiguous end. But now, if the status the basis of the EAD card, that category is actually ending, the work authorization expires immediately. Or the moment a person gets a final removal order if they are going through removal proceedings. So this applies broadly to all EAD cards across all categories, not just the narrow three, which I will discuss a little bit later for those changes. And this can be an undercover compliance risk for employers because you may not get notified when the underlying basis ends for someone's EAD card to then also trigger that expiration. So it could cause some risk for failing to timely re-verify employees for the I-9 compliance requirements. So this could be something that does impact employers. That could be something that they do need to figure out how to kind of have some kind of safety net to make sure that re-verification for the I-9 is not falling through the cracks, because it's going to be really hard for employers to know when these underlying reasons for the EAD ends when it's not also the expiration date that's on the EAD card. Now shifting gears to the second set of changes that are related to 3 narrow EAD categories. So these changes now are only related to parolees, which is the EAD category C11, deferred action recipients, which is the EAD category C14, and people who have final orders of removal who have been released on supervision, or people who are on supervision, as I'll refer to them as, EAD category C18. So here's what changes for these categories. The supervision category is actually almost disappearing entirely. So for people with a final order of removal who've been released on supervision, this EAD category is going away except in a very limited situation. And that is if DHS has tried to remove this person or deport them, as some people call it, and every country that DHS asked failed to issue a travel document to that person, they can then apply for employment authorization while they wait. But normally, if someone has a final order of removal who's been released on supervision, they will not be eligible for employment authorization anymore unless they fall into that narrow category. There's also a narrow category as well for people who are released on supervision but have been granted protection under the Convention Against Torture under CAT. So they can still apply for employment authorization. The second change is that you will need to prove, or these workers will need to prove that that they have a real economic need when they are applying for the employment authorization for all 3 of these categories. So this is a new requirement for parolees. When you were applying for a work authorization document under deferred action or on supervision, you did have to prove a real economic need. Now the standard is going to be higher, and it's also going to be a requirement for parolees. So for example, parolees could sometimes apply for work authorization right off the bat if they were going right into then applying for a TPS, temporary protected status. It was to kind of bridge the gap while the TPS application could be pending. So now parolees are not going to be automatically allowed to apply for work authorization unless they are able to show with documentation that they have a real economic need. And another change coming out of it for these 3 categories is, at least for 2 of them, is with deferred action and people on supervision. The work authorization is only going to be granted in increments of 1 year now, so it's shorter. So that could be a quicker turnaround for I-9 re-verification, just something to consider. And then from the first bucket of changes I discussed, the automatic termination, if the underlying basis for the EAD, if that ends, that's going to apply here too. So if a parolee or if parole or deferred action ends, that's the underlying status ending. That EAD card connected to that is automatically going to end as well. And again, you might not get notice as an employer right away. Now, this last change is the biggest one that I think is going to impact employers when it comes to I-9 and E-Verify compliance. So, to renew one of these 3 categories, and it's only for these 3 categories, so C11, C14, or C18, the worker has to be employed by or looking for work with an employer who's enrolled in E-Verify and in good standing. So this E-Verify is voluntary for most employers. There's only a limited federal mandate if you have federal contractors under the FAR. But this is almost going to be like a backdoor E-Verify requirement for employers, because if you have workers with EAD categories C11, C14, or C18, and then they go to renew that work authorization with USCIS, that employee is going to need to prove to USCIS that their employer is enrolled in E-Verify and in good standing. So if you're an employer and you have employees with these EAD categories and you want to keep them, you're going to essentially need to consider, if you're not already enrolled in E-Verify, should you enroll in E-Verify to keep this worker, which again, a whole new compliance beast, because E-Verify comes with its own compliance requirements in addition to the I-9. Then there's also a logistics wrinkle that comes out of this. So when the employee is then applying for the renewal of their EAD, the burden is on them to prove that the employer that has hired them or will hire them is enrolled in E-Verify and in good standing. So employers might start getting questions from employees about their E-Verify company ID number, because the employee is going to be provided to, or is going to be required to provide that to USCIS. So this could cause a little bit of friction in the workflow, or also confuse some employers if employees are starting to ask for this number. That could be why. So if this rule becomes a final rule, that's something that could come up in the E-Verify context. Now, also from this E-Verify requirement, which I'm kind of saying is like a new potential E-Verify requirement, this could be another anti-discrimination trap. So when you use E-Verify, you have to use it consistently for all employees across the board. You have to also make sure during the I-9 process that you're not asking improper questions during hiring and screening, to make sure that you are not discriminating against national origin. So this rule, because now there's going to be this weird requirement during certain situations for certain EAD categories to be enrolled in E-Verify and in good standing, it's going to make employers want to ask questions that you're not legally allowed to ask. And so, for example, you're going to want to potentially ask for the worker's EAD category if you're trying to hire them or you go through the I-9 process. But essentially, it's very strict. You can't talk about EAD categories until you're doing the I-9 and you actually see it. And at that point, you could note it for your records. But asking questions before that or at any time, it can really be the type of situation that gets an employer sued for discrimination. So there could be some real compliance risks about these E-Verify requirements when it comes to these specific EAD categories. I do want to say, like I said, this was a very high-level overview of this proposed rule. It is proposed rule. It's not a final rule, so nothing has changed yet, but there are things to start thinking about how it could impact your operations as an employer going forward. I will be covering this proposed rule in greater depth with a legal analysis in the upcoming HR I-9 compliance cohort. So as you may have seen, I have been pushing the HR I-9 compliance cohort to launch in June, but then there was a couple of different changes from a regulatory perspective for I-9 E-Verify compliance that I decided to push it to September so I can incorporate these things into the curriculum. And this proposed rule is one of them. I'm going to go do a much deeper dive into how to prepare your company to make sure you're not violating discrimination laws, and to make sure that you have systems in place to properly track EAD categories to make sure you're not falling into any potential non-compliance with E-Verify and I-9. The I-9 space. So if you're interested in signing up for the HR I-9 compliance cohort, it's going to be a small group, only 15 seats. I will drop the waitlist in the comments, but like I said, it's a type of training where it's going to be one-on-one with me on Zoom. It's not just me talking at you. I'm going to really show you the legal backbone of I-9 and E-Verify compliance. So I hope you can join me. Again, my name is Emily Brown with Elevate Justice. I will see you next week, same time, same place. Take care, everybody.